So what is comparative fault and how does it affect you in your injury case in California? Would you like to know more? Well, stick around. I'll be sharing some valuable insights into this particular legal topic. So comparative fault, what is it? Basically in California, when you're injured and you're partly at fault for your injuries, let's say you were injured in a car crash, slip and fall, product defect injury, anything like that. If you're injured and you're partly at fault, then your portion of fault will be compared to the portion of fault of the other party involved. So there usually will be a percentage given to each party at some determination, whether it's with the insurance company, judge, or jury. And so that's comparative fault. Why is it important? Well, a good injury lawyer can help argue facts to help minimize your portion of fault in a comparative fault analysis. And this is really unique in California because other states don't do it this way. Some states have what's called contributory negligence or contributory fault, which means that if you injure yourself or get injured by someone else and you're more than 50% at fault for that injury, then you can't get any recovery. So it's all or nothing rule in that regard. But here in California, it's different. We comparatively compare the fault between the other party or parties involved. So a good injury lawyer can help minimize your exposure of fault in that situation. Here's an example. Let's say that you're walking down the street, you're distracted, you're looking at your phone, it's nighttime, a car comes up on you, they're speeding, they don't have their headlights on either, and they hit you and they cause an injury. We've got two parties, you and the other vehicle driver. Well, let's say a judge or jury figures out that you're 50% at fault for your own injuries because of what you were doing and 50% on the driver for what he or she was doing. And let's further say that your case is worth $100,000 for all your medical care and pain and suffering. Well, you would get the judgment for the $100,000, but then it would be deducted by your apportionment or comparative negligence in that fact pattern, and that would be $50,000. So you would net $50,000 from that $100,000 award. So that's how it would play out in a real life analysis. If you have any questions or other concerns about comparative fault in California, I take calls like that all the time. Feel free to get in contact with me. You can call me. My phone number and email or web address should be on this video. But more than happy to help if I can. If you have any other questions when it comes to comparative fault analysis in California, you can always communicate with me on that as well. So hopefully this gives you a little more insight into what it is and how it's different and how it can help you and how you can team up with a good injury lawyer to help you further your cause with the facts to help further your cause, whether or not you were less at fault or more at fault. So with that said, have a great day, and as always, stay strong. Bye-bye.